the reasonable excuse are cruelty, impotency, dowry demand, false accusation of adultery, refuse of cohabitation. But my lord, there is no reasonable excuse for withdrawal. That's why I request to you the right of restitution, conjugal rights, and under the section 9 of Hindu Marriage Act. Ma'am, I will include something for the respondent side. That is, now a time human have opportunity to do a work in any places, government and private. After to continue the decide of family father home during the course of the employment, initially Rajesh and their parents did not object to it. But after some months, Megha refused come to the matrimonial home and she does not want to come on any government holidays. Now the Megha have excused the distance from workplace, as we know that the festival holidays are available in every government job. My lord, I want to tell you something which will be make the marriage stronger. In Hindu Marriage Act, in Hindu, they have both having a duty to leave each other and enjoy their society. To do separate without any reasonable excuses. My lord, Megha, whatever excuse he is giving totally baseless. A question arises distance from workplace is reasonable excuse for separation. It is correct at all. In custom, the tradition is going in India. Marriage is a union of family, and what strangeness the society and the civilization of society is established. I would like to include some historical facts that is not in mentioned. Okay, as we learned in the great book of Ramayana, we learn about Sri Prabhu Ram and Ma Sita. They will separate sometimes each other, but Ma Sita will never think about to separate about themselves. And now a case as we learn about Atul Subha's suicide case. Separation is not a solution, and in this case Megha have changed their mind and got the government job, and she live with his house with the parents, and also she is only thinking about himself, not about husband and not about husband parents. Independent does not absorb from the basic duties of marriage, including the cohabitation, compensation, and mutual support. And this is a bysides of Megha. This is an absence of practical session of the dispute. And I would like to put by the sides of evident house in the few lines with whom there will be clarity in matter. Error in the trial of court decision, misrepresentation of financial independence, absence of effort and compromise, legal precedent and judicial interpretation, imposition of unreasonable burden, incapability of right of life to Article 21 of the Constitution, judicial precedent of supporting of necessity of marriage, judicial precedent supporting of financial independence does not override the material duties. I would like to include a case in Daya Prasad versus Bhagwati held that was held to be the not reasonable excuse for the living apart. Sorry, no? Sorry, pardon, my lord.
Did not mention?
No. My second issue is whether the section 9 of HMA Hindu Marriage Act 1955 is constitutionally valid. Yes, the section 9 of the Constitution, section 9 of the Hindu Marriage Act in 1956 is completely valid. There is three important requisites to the fulfilled by the section 9. Spouses must not stay together and withdraw from the party from the other must have no reasonable ground from such withdrawal. The aggressive party must apply for the restitution of conjugal rights. Constitutional validity of section 9 to be noted that restitution of conjugal right clearly violation right of the privacy of the wife. In Kharak Singh versus State of UP has held to right of privacy essential integrates of personal liberty. And one other case is in Govind versus State of MP. Concludes that the right of privacy among the other rights include the right of liberty. Now, in judicial approaches, there are two judgments are conflict to each other in a high court. The first is T. Sarita versus Venkata Subha by 1986 in Andhra Pradesh at section 9. In this case, the violation of Article 14 and 21 of the Constitution. The spouses are not happy in their personal life, and invention of the rights of privacy and court will be enforced spouses. They come back their parents, and but it is civil and permanent remedy. Now this case will be included in the other high court. In Delhi High Court give their decision just opposite in this case. In Hadvinder Court versus Hadvinder Singh, 1984 Delhi High Court. Section 9, not violation of Article 14 or Article 21 of the Constitution. In two cases of High Court, they will be conflict each other. That this case goes into the Supreme Court, and the Supreme Court of decision is that is the basis of upheld that the law is valid Section 9 of Hindu Marriage Act, and say do not withdraw without any reasonable excuses. If reasonable excuses, court will be checked and they give the judgment. And it is not a violation of Article 14 and Article 21 of the Constitution. Supreme Court says that the Hindu Marriage Act is presumed that the both spouses they have some responsibility and obligation from themselves and valid with it met a healthy relationship with any reason they can withdraw. Now submit before your Lordship the counsel pay for the prayer. Whether the light and the fact state issue arise, authorities and argument advance and most humbly pray for the honorable court that it may be pleased to direct dismiss the appeal of the respondent and upheld the constitutionality of for the provision of restitution of conjugal right, Hindu Marriage Act 1955. We have passed any other reliefs, and this honorable court may deem fit and proper and the interest of trust and equality of good conscience.